to be here at Dawson again. I've seen the group grow from year to year, and it's always a pleasure to come back and address the seniors here. Hopefully the message we give you today can be a little helpful. I love the topic, living the second half. You know, there's an old saying that the first 50 years of our life we collect, and the second 50 years of our life we have to give away. So I'm on that second 50 years. So my husband's packing up the boxes as we speak. We just finished a kitchen remodel. So needless to say, it's amazing how many can openers you can accumulate in 30 years of marriage. And what better use is to send it on to a younger couple or someone trying to establish a kitchen. But that's always fun, and I know you all are facing those same issues. I like to simplify things. The more clutter we have around us, the more confusing things get. Need I go into that topic, but we'll save that topic for another day. Today we're going to talk about estate planning. Now, jokingly, we think the older we get, we need to do our estate planning. Well, seriously, the older we get, the time is way past for us to have done estate planning. I see a fellow lawyer in the audience, and I know Calvin can testify to this, but when we become 19 years old in the state of Alabama, we become adults. Prior to 19, our parents made our decisions for us. And younger than 19, even at 18 and 16 and some younger ages, we have certain rights that we have. But at 19, we have a full catalog of adult rights in Alabama. So it goes without saying that at 19 is the first time we should establish our own estate planning documents. Because at 19, we could have a car, we could have a bank account, we could have inherited part of our grandparents' estate. So at 19, we have those decisions we will have to put in place. So that one, if we pass away, our wishes are followed. And more importantly, if we become incapable of acting on our own and making our own decisions, what are the lifetime documents that we have in place that we can fall back on to delegate those decisions without having to go to court? Every time I go down to court, the judge says, "Lynn, are you doing okay? I never see you around here." I said, yes, great. My planning's answered because I want to stay out of the courtroom as much as I can. I don't have fun, my clients don't have fun, and it costs money that we can avoid having to spend by doing planning ahead of time. Now, in estate planning, we have a couple of documents, and I'm going to confess a little bit. My situation is I was born too early. Has anybody ever had this little issue about dealing with computers and electronics and certain things? Well, I am as nervous as a cat having this electronic in my back pocket. I'm nervous as a cat dealing with this computer because, why? I was born too early. When we interview new workers for the office, the first thing I ask was, what year were you born? If it's anything after 1980, I know they have a grasp of the computer. I spent 15 minutes on the phone with the website today to ask them, where is your log on button for the website? Well, the lady says, do you see it in the top right of your screen? Absolutely not. She says, well, you've probably blown up the screen to see it better. I said, you're right. So I shrunk it down a little bit, there it was. So I was born too early. So if anybody ever asks you, what's going on? In other words, you're at the grocery market, you're trying to write a check, you have a credit card, and folks behind you are just pushing you on, you say, excuse me, I was born too early. Now, by the time they figure out what that means, you've finished up your business, put the checkbook, put the credit card back in your wallet so that you don't get to the car and go, oh my goodness, did I leave the credit card at the counter? So please, borrow that statement, I was born too early. It doesn't say you're old. You were just born too early. Okay. On our estate planning packages, we call it, the different items that we need to make sure we have in place, what would those be? Well, the last will and testament, that's when you die and how are your assets distributed. I tell my clients that's the one document I am least worried about. I am more worried about what's going on in your life right now and while you're living. Are you it may make sure your finances are taken care of, your health care, all of your lifetime decisions. And that will lend to the necessity of the next set of documents, meaning the durable power of attorney for financial affairs, as well as the durable power of attorney for health care. And then we also have the living will, which addresses your end-of-life wishes. And not to forget those very important and very confusing beneficiary designation forms. When I ask clients about those forms, the deer in the headlights look comes across the table. What do you mean? My will leaves it all to my children or to my spouse. Why do I need a beneficiary designation? We're going to address that issue at the end of this talk. And of course, later on, as you have other estate planning needs and other estate planning considerations that have to be addressed, whether or not you need a trust, whether or not you have to do tax planning, whether or not you have any disabled beneficiaries or a disabled spouse who might be in a nursing home where we are trying to protect their Medicaid eligibility. So that's the basic documents that we would see in an estate plan. Now, let's talk about the last will and testament. And you understand, that's the one document I'm least worried about. When the personal representative in the will who's been appointed by you comes to see me, I have usually had to call, and I've been to the hospital, and I have spent the last year or so dealing with the sickness. So I'm generally well aware of my clients and how they've met their final creator. But usually in the last will and testament, I know you're in a better place by the time the family comes in without me. I know we're in the finest place that we could ever imagine, and that we prayed for and prepared for all of our lives. So at least you're in a good place at that point. Now, for a will, you have to be age 18 to sign a will. It's kind of interesting because the will, to be witnessed, the witnesses have to be adults. So the witnesses have to be age 19, but you can be 18. And I really think that has something to be said about going to war, being able to fight for your country at age 18. You want to make sure you have the ability to sign a will and be able to dispose of your assets. Now, legally, you really couldn't have sold them during your life. You could have written a will, but it's just an interesting age difference. 18 to do a will, 19 to witness it. A will has to be a written document. It can't be verbal, and it can't be handwritten. In some states, they will honor a handwritten will. Now, a handwritten item will have a very persuasive effect, but I would not want to depend on handwriting that you've had notarized, because a will requires at least 2 witnesses. I've had handwritings or written documents that clients will come in and show me, and it has been notarized. Well, there's no other witnesses. So I only have one witness, who is the notary. So if it's a typewritten document, notarized, it's not a valid will. Of course, the will has to have the 2 witnesses and a notary to be self-proving. And Calvin's shaking his head. Because you know why it doesn't, what has to happen when you don't have that magic language. And the magic language is, the testator or testatrix has signed in the presence of the witnesses, 2 witnesses, in the presence of each other, and before a notary. And we recite very specific information. It can't be signed and then witnessed later. It could, but it's not self-proving. Well, what's so special about self-proving? Self-proving saves us court costs. A self-proving will, we can take that will, we take waivers of the next of kin, we take the waiver with the petition downtown, and at the window we are issued letters testamentary, and the will is probated, and the probate of the estate administration begins that day when presented. That's why it's so important to have a self-proving will. If you don't have a self-proving will, we have to bring testimony. We generally have to have a hearing. We have to go find the witnesses. If it was a will signed 30 years ago, well, 30 years ago I was still around. but some of my clients' witnesses may not still be around. First will I ever probated? Unfortunately, it was not a will I had done. It was a will signed by 2 witnesses. I had no idea. I said, well, let me find out how to start. So what I did is I opened phone book. I found the witness, and surprisingly, the witness, I called the witness. It was the same address, same phone number. She knew this gentleman, was sad to hear he had passed away. And I said, oh, by chance, do you know the other witness? Oh, yes, she's my neighbor. So how lucky could somebody get finding the 2 witnesses who were willing to go downtown and sign the statement to prove the will? So you've got to make sure you have the self-proving language. Sometimes I'll tell my clients when they come in and they bring their documents, I've got a famous saying, if it's not broken, I don't fix it. I borrowed that from somebody. But if it's not broken, I don't fix it. If it requires a rewrite or more time to rewrite certain documents, we'll juggle whether it's worthwhile, whether we really need to spend the money to save the money down the road. So we're juggling economics. Now, next slide, and forgive me again, I'm going too early. I'll keep telling you that again. See, I've already gone through the next slide and I skipped it already, so I hope y'all are keeping up with me. All right, so why do we need a last will and testament? Well, imagine you passed away and did not have a will. When you leave off and don't do your planning, the law does it for you. And that's called an intestate distribution. If you've not written a will, the law will distribute your assets for you, and we'll talk about how that happens in a minute. You want a will to where you have, makes your wishes known. You want to be able to waive certain requirements. Well, what requirements would that be? A bond. If you don't waive bond, you've got to spend money, post a bond to administer the estate. And a bond could cost a couple of $1,000 depending on the size of the estate. You may not be bondable. Sometimes I've had folks who had too many traffic tickets, and the bond company did not want to bond them because they thought they were a big risk. Well, somebody who's careless on the road and can't drive safely, how can they be careful with money? So a bond is to protect what the personal representative may do and protect those potential beneficiaries from the personal representative abusing, losing, miscalculating the estate assets. Another item you may want to also waive is inventory and accounting and potentially a final settlement. But no matter what the will waives, that personal representative, who's also called your executor, has responsibilities to the beneficiaries. Even though you don't need to do a formal inventory and file it in court, even though you don't have to do formal appraisals and accountings in court, you best believe you better be reporting to the beneficiaries, because communication is the best way to handle an administration. When we begin an estate, we have the administrator, we have the personal representative, we add up all the assets, we tell the beneficiaries what's there, what are we likely to be doing with the will, where are we going, how long it's going to take. If we have special gifts in the will, like the house goes to the oldest grandchild, that will be made known. If we don't have special items, and perhaps we have the family house, I make sure that if any beneficiary wants to buy that house, they better speak now or forever hold your peace, because how do you take one house and divide it among five or so beneficiaries? Another item, the reason why you want to do a last will or testament is protect your privacy. You don't have to file all of these items in inventory in court if you waive the inventory. If you waive the inventory and none of the beneficiaries object, you could literally probate an estate with a petition that says, here's the will, here's the petition for letters testamentary, the personal representative is issued those letters, personal representative gathers the assets, pays the bills, and then distributes to the beneficiaries. If everyone is in agreement, they can sign a consent, and there's never one document in court that ever is reflecting what bank accounts you had and what your net worth is. Now, if there is a minor beneficiary, a child, you've got to do an atonement, because a minor cannot waive notice and they cannot consent without going to court with a full atonement. What we put in our wills, Calvin's shaking his head, any other attorneys shaking their head here also in agreement, and clients who have had this done. If there are any minor beneficiaries or beneficiaries who no longer have mental capacity, you want to make it a trustee, because then the beneficiary doesn't have to consent, but the trustee can. And that way we stay out of court. Now, one main item of making sure you have a will is to prevent intestate succession. Now, I'm going to let you look at the next slide, because this is the most fun for me. It's the math. But I'll walk you through it. This is how an estate will be distributed if we had $300,000 and there was no will, and the decedent passed away with this amount. If the decedent on the first line had no children and had parents, then each of the parents would split the estate. So 300 divided by 2 is 150 to each parent. Now, if the decedent had 2 children and living parents, then the children split with the parents. Now, in estate planning situations where you're trying to move the estate value down to the generation, you don't want them to happen back up. Because now the estate exemption is $5,640,000. It's big before you end up having an estate tax. But years ago, I remember when it was about $600,000. Years ago, when I was a paralegal, don't laugh. I remember when it was $125,000. It was teeny. So you can end up passing away with the house, maybe one life insurance policy, and you end up having an estate tax. In today's rule, if that person did not have an estate, did not have a will, the parents could have had issues in their estate tax, could have given the assets to the child, or the child could have accumulated their own assets, and now the parents are going to receive this asset back. I had the same situation occur in a situation on a Medicaid case. Husband and wife gave the child all of their land and reserved life estate. They did this 20 years ago. The child died. No will. Where does the parents' property, where does that property now go? Back to the parents. Because the child had no will. Guess what? Mama's in a nursing home. So we start over. And we did some very creative planning. Because in certain rules, a husband can give his wife a gift. And that's what we did. The husband gave the wife the gift. The wife did a new will with the trust for the husband to protect it from being counted again when the wife passed away and getting counted again for Medicaid purposes. And very sadly, wife just passed away about 2 months ago. So Medicaid's just spinning their head right now. When you use the rule well first, and you use the rule to protect somebody. Yes. And there were other relatives who would end up inheriting. But the trust is there to protect the Medicaid spouse. Now, in this next piece, we've got the situation where we're married and we have our parents. In a marriage situation, the spouse gets the first $100,000 and then half of the rest. So here, the spouse gets the first 100, there's 200 left, they get another 100, and then each parent splits 50. I wonder if my husband did not have a will, I wonder if he really meant to leave his parents half of the estate after I got my 100,000. I don't think so. But luckily, early in our marriage, we had wills done. Long before I was in law school, too. Now, we have a situation where we have no children and no parents, and the spouse inherits all. The next situation, we have 2 children, a surviving spouse. Now, when all of the children are also the children of the decedent, in other words, mom and dad are the mom and dad of all the children, one marriage and one set of children, no stepkids, then the spouse can get the first $50,000 of the estate. and then the spouse splits the rest with the children. Now, money's easy to distribute. Imagine if there was a house in Dad's name, Dad passed away and had no will, and his wife was living in the house. Mother now finds herself as co-owners with the children. Imagine how messy that can get. Once the kids move out, you want them to stay put, right? You don't want them to move back in, but now they potentially own the property. So you see how important it is to make sure you have a will? You walk through the plank, you walk through the scenario. What if I don't have a will? If I don't have a will, the law writes it for me. It's kind of like the IRS. Anybody not ever do a tax return? I had a little lady in the nursing home for probably 4 or 5 years. At the beginning, we had to sell stock. 3 years later, the IRS sent us a statement saying, you owe $30,000 in taxes. And the son brings me the letter and says, I guess we'll pay it. I said, no. When Mom sold the stock, they counted the gross proceeds as full proceeds with no basis. I know that's a technical question. But they counted her as selling $100,000 of stock and having $100,000 of profit. So they sent her a $30,000 bill. So all we did was go in and beg forgiveness. It was overlooked. The accountant filed a tax return. And then the son ended up getting a refund for a prior year that they had forgotten there should have been due a refund. So, needless to say, in the law of intestate succession and the law like the IRS, if you don't do what you're supposed to do, they'll do it for you, and you may not like the result. Isn't it fun? Moving on. Oh, we're on dessert? Yeah. Now, in the will, you're naming an executor. You know, in this modern age, we used to call in days of where I grew up, the executor who was a male was the executor. The executor who was a female was the executrix. Now we've got everything neutral gender. Now we call everybody personal representatives. Why? That's just, it makes it easier in drafting. But the personal representative is generally the executor. The question is, can you name more than one personal representative? Well, imagine you're walking down the road and 2 people are trying to walk in the same set of bridges. It's going to be hard to travel. That's sort of like what happens when you have 2 co-personal representatives. Lots of times parents want to have all the kids on one piece of paper, and I try to convince them. I said, if you name all 3 kids, we have to have that same piece of paper signed by all 3 kids. We can't go open up a bank account with all 3 kids on it. A bank won't even do that. It would generally have to be a brokerage account where they require 3 signatures, so it makes it very difficult. And I always tell my clients, I say, well, if you have to blame it on somebody, blame it on me. Because I'm asking you for a number 1 person, a number 2, and possibly a number 3. Because if number 1 can't serve, or passes away, or is incapacitated, it leaves a successor who can be named. And a successor who can be named is you have waiver of bond, and they can act as the personal rep. And I always like to have, I said, look, it's not going to cost you any more money to have a 3rd person named. But make sure that person has good sense. Because they have to be able to operate and act and handle money and property. So I always want to make sure that we have a successor and maybe 2 successor personal representatives. Now, what does a personal representative have to do? When we begin an estate, the first thing I want to see is, what are all the assets? I don't probate, I don't follow the will in. We want to see a copy of the will, and we want to see a list of all the assets, and bring all the bank statements in, all the insurance policies. Because what we may end up finding is, everything either has a co-owner or a beneficiary. Now, that leaves sometimes the personal property in the house. I generally will not want to probate a house of just a house full of furniture. We want to make sure the bills are paid, that we have not prejudiced any creditors, and that we have put the beneficiaries in possession of the asset. So we'll say, look, you want to pay these final bills, and we avoid probate. Well, if you don't want to pay these final bills, we're going to file and we'll have to probate a house full of furniture. Sometimes we have a very valuable house full of furniture, and sometimes not. But we're always looking at the economics of having to probate the assets. The responsibilities of a personal representative in the estate would be collect and protect the assets. We make sure our debts and our taxes are paid. We want to take control and manage and make sure insurance is continued on cars and houses. And then ultimately we distribute. Now all of those assets have a co-owner, and we're looking at it. I'll generally tell the family, look, there's no probate estate other than the furniture. We don't want to prejudice a creditor, so if we have a bill, a file bill at the hospital, let's pay it out of whoever inherited the money, and that's realistic. Because that's what we would end up doing anyway in a probate estate. Now, if everybody's fussing on it, I would generally let the beneficiaries all come to some conclusion. Because I don't want to have to diminish. I don't want to have all the assets